Assalamualaikum and a good day for everyone. My name is Sheikh Rizwan bin Jihad. My matric number is 273025 and I am presenting about striking out pleadings. So the first one is striking out pleading. The provision relating to this is Order 18 Rule 19(1) ROC 2012 that stated the court may at any stage of the proceedings order to be struck out or amended any pleading or the endorsement of any writ in the action or anything in any pleading or the endorsement on the ground that A. It disclose no reasonable causes of action or defence as the case may be. B. It is scandalous, frivolous or vexatious. C. It may prejudice, embarrass or delay the fair trial of the action, or D. It is otherwise an abuse of the process of the court and may order the action to be stayed or dismissed or judgment to be entered accordingly as the case may be. And for the definition of the struck out case, struck out a pleading is where one of the parties of the suit applies for the pleading to be struck out of the court. Next, for the part of who can apply this, of course, the first one is the plaintiff, which is to strike out the defendant's defense or counterclaim, either whole or part of it. As for the whole, the court will give judgment to the plaintiff, and as for the part of the claim, the court will examine whether the remaining defense of the defendant is enough to sustain as the defense to the plaintiff claim. And the secondly, for who can apply is of course also the defendant, which is to strike out the plaintiff endorsement or writ, or to strike the plaintiff statement of claim, either whole or partly. As for the whole action will be struck out from the case, and for the part, the court will examine whether the remaining portions of the statement of claim are still sufficient to bring the cause of action against the defendant. So we move on to when it can be happen. So the application may be at any stage of the proceedings. However, the application should be made as soon as possible, as has been discussed in some cases. These cases outline three things regarding when the application of striking out must be made. The first one is promptly. The second one is without delay. The third one is preferable to be made before the close of the pleading at the early stage, which is 14 days after the delivery of the last pleadings. According to the case of Jamil Hassan against Kang Min, the court held that the party that delayed the application to strike out the case affect the party's chances to succeed, and application will not be entertained if the trial has been set down. So, what is the procedures of striking out the case or the claim? So, the first one is the parties must file a notice of application and be supported by an affidavit. Second one is this affidavit in support must state the ground of the application provided in Order 18, Rule 19. And the application must also state the order sought from the court whether to strike out the whole or part of the pleadings. And it has one exception, which is if the application was made relying only on the first limb under Order 18 Rule 19, the court must consider limb A first without looking at the affidavit on the surface. Next, we move on to the ground of striking out. So the first ground is according to limb A. The first one is no reasonable cause of action or defense. That means both plaintiff and defendant may apply under this limb on the surface of the pleading that there is no reasonable cause of action or defense. The applicant cannot leave evidence in the affidavit in support to prove, as there is no reasonable cause of action or defense, and a weak cause of action is not a ground of strike out. It can be referred to the case of Law against Lewin. And the second one is according to limb B, regarding to scandalous, frivolous and vexatious. Both plaintiff and defendant may apply under this limb. Scandalous, unpleasant, unnecessary, and aiming to insult or embarrass the person. Scandalous, wholly unnecessary, and frivolous action. It is a groundless with a little prospect of success. And vexatious is an action to annoy, oppress, or harass a litigant. It is hopeless to the law, and it can be referred to the case of Pertamina against Kartika Ratna. And the third one is limb C, which is prejudice, embarrass, or delay the fair trial of the action. Both plaintiff and defendant may apply under this limb. For example, a defendant is filing a defense that merely contains bare denial against each and every statement in the plaintiff statement of claim. And the last one is limb D, which is no abuse of process. Both plaintiff and defendant may apply under this limb. This limb is wider than other limb as it cannot fall under the other limbs. Abuse of court process is where the process has been used for improper purposes instead of genuine and bona fide purposes. It can be referred to the case of Remington against Scholes. And for the last slide, which is the circumstances for an application for striking out to be dismissed, there is three circumstances that have been considered, which is the first one is when the lacking facts or particulars may be cured through amendment. The second one is when there is a reasonable cause of action even if the case is weak. And the last one or the third one is when there is a reasonable cause of action even if the case is weak. With that, that's all my presentation for the topic that I choose. Thank you very much. Assalamualaikum warahmatullahi wabarakatuh.